discovery is not only used to gather evidence, it's also used to limit evidence. So a lot of times we hear that this person has this or this person has that, or they've got the smoking gun or the infamous pot of gold at the end of the rainbow, which I've never found to this day, but it's there in almost every case. But it allows you to call somebody's bluff also to get all the facts on the table so everybody knows the playing field. I think that's the most difficult thing in a contested, highly litigious case, is to find out what the playing field is. Each party has an idea in their mind of what the playing field is. The attorneys try to gather the information, and they can only rely upon their own clients and possibly what the other side will let them know is going on. But it's really hard to determine the playing field. The more effective that attorneys are in establishing the playing field, the better off both parties are, even if it's a highly litigious case. And then judges want the playing field. That's why you have discovery. The judges want plenty of time for the parties to have the information, for them to exchange it, for everybody to have inventories and appraisements, for everybody to know what's going on, any of the emails, the photos, the text messages, the police reports, the criminal records, the audio recordings, the video recordings, photos, anything that you're going to use as a part of your case or that you may want to try to limit the other side using. The judge wants everybody to exchange that well in advance. Judges do not want to have a trial within a trial trying to figure out where the playing field is. Judges appreciate that, and it's essential and imperative that clients make sure that they retain a firm that understands how to set the playing field in a litigious case, and that they can go into court without mumbling and fumbling and bumbling and stumbling over themselves to either try to limit evidence or to try to get into evidence. I think there's a major difference between being able to practice law outside the courtroom and practice law inside the courtroom. And while I'm biased, I think we're able to do a great job of that because we have a really good experienced staff. We have a really good set of attorneys that can go into court and know how to try a case if it needs to be tried.